Thank you so much for the introduction, Vivian. And thank you very much, Mark, for volunteering to present today. I just wanted to, and hello to everyone. It's really nice to see all of you in the CCSF Center for Entrepreneurship. Thank you very much for having us today. I just wanted to say a few words about my program, Legal Services for Entrepreneurs. So we're housed within an organization called Lawyers Committee for Civil Rights of the San Francisco Bay Area, or LCCRSF. We provide direct legal services, as Vivian mentioned, to low and also moderate income people in the San Francisco Bay Area who want to start businesses, operate an existing business, and then also to people who want to invest, to businesses who are committed to investing in low-income communities of color in the Bay Area. We provide not only workshops and webinars such as this one, but also brief legal advising sessions of 1 hour each, and then also longer-term limited scope legal assistance. Our program is powered through volunteer attorneys, like Mark. We have lots of amazing volunteers, including you, Mark, and we offer our services in 5 different areas, our advising services in 5 different areas: employment law, entity choice information, intellectual property, commercial lease, and contract drafting and review. So to apply for those services, you can fill out our application form online, and then a member of our team will contact you for an intake interview and talk to you more about how we might be able to help you, and then either place you with an attorney if you're eligible, or tell you how else you might be able to get help with your legal requests. So I will paste my contact information and the link to our program webpage and our application form in the chat, so you all have it for reference. And with that, I'd like to hand it over to our amazing and longtime volunteer, Mark Mihanovic.
Thanks, Tobias, and thank you, Vivian, for that kind introduction. Just in terms of LLC, I can't say how much McDermott appreciates the work we've been able to do with LSE over the past many years, whether it's in presentations like this, although when I say like this, I don't mean Zoom, I mean in person, but similar types of presentations, or it's clinics that we assist with, or the client work that's referred to us through LSE. It's all been very rewarding, and my firm is very grateful for the opportunity to work on a regular basis with LSE, and look forward to continuing to do so.
Thank you.
Vivian's description of me was more kind and glowing than I could ever hope to accomplish myself. I will say a couple things about my firm, McDermott, Will & Emery, which is, we are a firm of around 1,100 lawyers, 20 offices, 7 of them in Europe, 13 in the US, including 4 in California, 1 in San Francisco, Silicon Valley, Los Angeles, and Orange County. And our corporate practice, in which I have been a partner for many years, is our largest practice area. We have a number of other areas of specialty that support the corporate area and that have their own fantastic list of clients, including in the intellectual property space. We'll be spending a little bit of time in this presentation about on intellectual property issues, but we have a very strong group in that area. But I think as Vivian mentioned, I cover a few different areas across industries of corporate law, mergers and acquisitions, securities and capital markets, and then I do a good amount of work with emerging companies and the entrepreneurs that found them and that own them, and that's a very gratifying part of the practice for me. I very much enjoy working with entrepreneurs. So with that, maybe we can get started with the slides, Tobias, if you don't mind.
Sure.
And by the way, while we're getting set up, we should make this as interactive as possible. I will, certainly at the end of each section, I'll stop and ask for questions. And in the meantime, folks could feel free to lob in on the chat or raise your hand. I can't promise that I'll be great about picking those up, but certainly, as we go in the session, but certainly at the end of each section, I'll try to stop and people should feel free to interject and make this as much a conversation as anything else. I want to spend time on things that you guys want to hear about as opposed to what I want to talk about. So with that, can we go to the next slide? You can come through the disclaimer. There you go. Thank you. And so, we're basically going to talk about 4 main topics in this session. We're going to talk about, business entity choices and the considerations that go into choosing a business entity, including in relation to tax. We'll talk about, spend a little time on permits and licensing. We'll talk about contracts. As I mentioned before, we'll discuss intellectual property issues. And then if there's interest in time, I can walk through some of the documentation that are, you typically use in forming in starting up a corporation. And it's a long list, so I don't want it to make it too daunting, but happy to run through that, quickly with you if you like. And then we'll finish up with kind of a summary of some of the key considerations and resources. And again, I would like this to, be as interactive as possible. So I think we can go to the next slide. So we're going to start with the issues and considerations around a choice of a business entity. We can go to the next one. So this why do you need to form an entity for your business? We'll discuss various considerations in more detail, but this this chart focuses on the liability protection issues for the entrepreneur and for her or his personal assets. The left side entity types involve greater risk to the personal assets, and the circle on the right side show entities in which the entrepreneur's personal assets are generally insulated from problems with the business. But on the left side, we've got a sole proprietor, which it really, we'll discuss in more detail, but is not an entity at all. Then a general partnership. In the intersection there, the limited partnership is kind of in the middle, because there's unlimited liability that the general partner in a limited partnership is subject to, but then to the extent that the individual or entity is investing as a passive investor, as a limited partner in a limited partnership, then there is liability protection. And then we go to the circle on the right, and we're talking about limited liability companies, corporations, and the like, and other similar entities in which there's unlimited or limited liability, where the problems in the business should not generally become economic problems for the owners of the business. Next slide. So in terms of choosing a business entity, we talked about the legal liability just now. Which entity type best protects the personal assets of the owner of the business? Another key consideration, a key issue, is which entity type allows the owner of the business to own and manage the business in the best way possible, the most, with the most flexibility, and in a way that protects the manager of the business from liability. And then a paramount issue, as you might imagine, for companies in deciding, or entrepreneurs in deciding what type of entity they're also, how is the entity taxed or not taxed is a key consideration. Next. So here are the entity types that we'll go through in more detail. The sole proprietorship. This is basically a business that's operated by one person. There's really no entity here. It's you start to operate a business under your name, and you are a sole proprietorship, whether you call yourself that or not. There's no separation from a legal perspective between the owner and the business itself. And as I mentioned before, they're in that context, the owner of the business, if you will, has unlimited exposure to problems in the business, to liabilities that may be incurred in the business. Then there's a general partnership, and this is any two or more people that are operating a business as co-owners, and this could be whether or not there's a contract. You could, two people starting a business together, arm in arm, don't have to sign an agreement, don't have to make a filing with the state to be considered ultimately a partnership. And so in this context, it's similar to the sole proprietorship in that there's no legal separation, no barrier between the owners of the business and the business itself. So if there's liabilities that are incurred in the business, like in the context of the sole proprietorship, the liabilities, the exposure could potentially run itself upwards to the assets of the owners of the business and subject the owners' cars, bank accounts, furniture, houses, etc., depending on what state you're in, but to liability for someone that's got a claim against the business. Limited partnership is, as I mentioned before, there has to be at least one general partner, and that general partner manages the business, and that general partner has unlimited liability, like the owners of a general partnership or a sole proprietorship. But then there's limited partners who typically become limited partners because they invest capital, but they're passive. They don't take part in managing the business, and so they are protected from liability. The LLP designation is a limited liability partnership, and those are typically professional services organizations that also involve limited liability for the owners, and that's typically lawyers. McDermott, Will and Emery LLP is a limited liability partnership where the partners in the law firm are essentially shielded from exposure due to the LLP designation. Limited liability companies are kind of a hybrid of partnerships and corporations. It's a business entity that is separated out from its owners. It provides the owners of the business with limited liability for the problems in the business, for the obligations in the business, but is a flow through from a tax perspective. So LLCs have become very popular in the last 25 years. 30 years ago, 40 years ago, there weren't LLCs, but in the 1980s, they started to develop and then became very, very popular as a vehicle of choice for startup, early stage businesses. And the LLC allows for a great deal of flexibility in organizing the governance of the company and allocation of profits and losses and determining voting power. And owners are typically called members in limited liability companies. Then we have the corporation, which also is a business entity separate from its owners. The owners of a corporation are shareholders. The owners are not personally liable for the debts or obligations of the underlying business in general, and there are exceptions to the extent the corporate formalities are not adhered to. But in general, corporations should shield their shareholders from exposure to corporation issues or corporation liabilities. Corporations are generally have two levels of tax, though. There's a tax at the corporate level, corporation level, and then there's a tax when the money goes out. We'll talk about that in a little more detail. Down there is a footnote that talks about S corporations, which are a specific tax designation, which have various limitations associated with them, but are corporations and are flow through from a federal tax perspective. There's only one level of tax. You don't have the two levels of tax in the corporation. I think I saw one question about whether or not LLCs can add members after formation, and the answer is yes. Typically, the LLC agreement, or what's called an operating agreement or an LLC agreement, will, and it may say with the approval of the other owners or a percentage of the other owners can add additional members as you move forward. Next slide, please. A little more detail on the sole proprietorship. Again, no legal separation between the owner and the business. Here, Gloria, our florist, has just decided to sell flowers and is not going to form an entity, is not going to do anything other than just sell flowers through a florist shop. And as a result, there's no issue with a separate level of tax, but the risk is if someone comes into the floral shop and a vase falls on her head and she ends up in the hospital, there's exposure there for Gloria individually beyond the business. While there's no formal requirement to make a state filing to form the entity, like any business, whatever licenses and permits are required for that specific business would still be required in the context of the sole proprietorship. Typically, Gloria might want to name the business something other than Gloria's business, and and what sometimes is filed is called a fictitious name statement for the name of the business, going forward, so people have noticed that business name has been taken. The key issues, again, legal liability. Gloria is fully liable for the debts and obligations of the business. We generally are very reticent to recommend that people operate through a sole proprietorship. Strongly prefer that businesses operate through an entity that's been formed, whether it's an LLC or a corporate entity. To the extent that the individual wants to avoid doing, the pain of doing filings with the state and fees that are associated with forming the entities, and wants to proceed as a sole proprietorship, we strongly would encourage then, as in the case in any business, there to be liability insurance obtained, for potential exposure in the business. But even with liability insurance, anytime you have insurance, there's the possibility for the insurer to say, I don't think I should pay on a given claim for X, Y, or Z reason. So again, that's the benefit of forming the entity, but certainly at a minimum, having liability insurance would be very important if you're going to operate a business through a sole proprietorship. In terms of management and ownership, that's easy. The owner has complete control over what happens in the context of the sole proprietorship. The taxes and fees are all passed through, meaning that whatever profits are in the business, there's no entity level tax. Essentially, all the profits go to Gloria here. If there are losses, that's the bad news, is that there are losses, but the good news is that to the extent Gloria has other businesses or other income, those losses are on her personal tax return and could shield and offset gains and income from other sources. So that's what we call pass-through taxation. Next slide. A little bit more on sole proprietorships. You pay taxes to the city, state, federal government. There you go. And again, from the individual taxes, there are self-employment taxes that would be paid in California. They're steep, up to 15.3%. Social Security, 12.4% of income, with up to the 118,000. 2.9% of income for Medicare, and then this 6.2 and 1.45% for employer and employee taxes. So the self-employment taxes in a state like California are extremely important to be aware of. Next slide. Okay, the next entity type we talked about here, we've got Maria and Pedro. They've joined forces and operate a cafe. Again, 2 or more people operating a business as co-owners, for profit, and that's a general partnership. Whether or not they have a formal contract or not, or can be viewed as such. But certainly if you're going to operate as a general partnership, I would advise it's very important to have some kind of a written agreement to set forth who has what responsibilities in connection with a in connection with the business, and who has what ownership share in the business, because I've certainly seen many partners and partnerships that when things are going well, and there's perfect alignment and there's never a disagreement, that might work, but typically that doesn't last forever. And so one or another partner might get down the line their nose out of joint because of they think they're doing more work than the other partner. They think they're entitled to more money. Put it on paper. Key issues here: all owners are jointly liable for the debts of the business. Again, in that context, it's important that the liability insurance be obtained by the business. In general, all owners are going to have an equal right to manage the business, and there's great flexibility in allocating profits and losses. And here's why it's important that if that a partnership agreement be entered into, if the intention is that things be other than 50-50. And so the partnership agreement is critical. Taxes and fees, again, it's one level of tax, pass-through taxation, no tax at the entity level. Owners receive income from the business directly, and they pay taxes on that income on their personal income tax returns, both federal and state. Next slide. I think we skipped over one. I can hit real quickly here. I think we missed one. There you go. Again, same thing, taxes paid to the city, state, and federal. You can see the income tax forms. What's in the context of partnerships, each partner gets a Schedule K1 that shows that partner's share of profits and losses. And then it gets the K1 from the company, and then the partner files a 1040 showing on their personal income tax return the profits and losses. Self-employment taxes, as we discussed before, in California up to 15.3% apply here as well. Next slide, please. Yeah. Limited partnerships. As we mentioned at the beginning, this is a structure in which there's one general partner or more, but there has to be general partners and there has to be a limited partners. And the limited partners typically invest capital. The general partners typically run the business. The general partners generally have unlimited liability. When I work on funds with clients, they typically, you don't see individuals acting as general partners with big funds, because they don't want, the individual doesn't want their bank accounts and cars and houses subject to exposure. So that general partner often will form an entity to serve as the general partner. But again, from a limited partner's perspective, it's typically a passive investment, and it can be important that the limited partner not take part in actively managing the business, because if they are too active in managing the business, their status as limited partner could be subject to challenge down the road. Here, we've got Juan and Rodrigo, in a restaurant, running a restaurant. One is an investor, the other is running the restaurant. I'm looking at, I just see a question. What's your personal opinion on setting up a limited liability company in a state you don't plan to live? I would say that for a startup company, it probably makes sense to form your entity in the state where you're going to be working and living. And the reason for that is, if you form for example, a limited liability company in another state, when you're just starting up, you're going to end up with multiple. You're going to end up having to pay fees, franchise taxes in the state where you form the entity. Plus, you're going to still need to be qualified to do business in the state where you're operating the business. So you're layering on another set of fees and some hassle in terms of filing additional paperwork in the business where you don't, in the state where you don't live. As companies get further down the line, though, people will typically, and you get closer to outside investment, maybe an liquidity event like a public offering or a M&A sale, or you're adding a lot of investors. There's benefits, and we'll talk about them a little later, to potentially forming in a state like Delaware, where there's a very well-heeled Delaware corporation law, and it can be to a great benefit to be if you've got enough critical mass. It could be great to form in Delaware and have the protections of Delaware law, and you're not as concerned because the business is of a size that can take both paying franchise taxes and filing, the hassle of filings in Delaware and California, for example. Limited partnerships, same issue in terms of filings, K1s and 1040s, and self-employment taxes at 15.3%, the same deal. Yeah, and I see Donald's comment here. And again, I think Delaware would be the state of choice if you decided to form, or the typical state of choice if you decided to form an entity out of state. Some people form entity. There's other states that have some popularity. Nevada, sometimes is where people look, but Delaware is the cottage industry in Delaware. That's where people typically form entities if they're going to move their entity out of state.
Sorry to interrupt, Mark. I see we have a question as well about switching from whether it's possible to set up a company as a sole proprietorship and then change to one of the other entity types.
Of course, yes, that's fine. And again, there's not a lot involved in setting up as a sole proprietorship. You start running a business and you are a sole proprietorship. And then, but if you started that way and then decided a year or 2 or 3 that it made sense to form an entity to protect your assets, that's not an unusual path. And at that point, you could form a corporation, whether a C corporation or S corporation. You could form a limited liability company. If you brought in a partner, you could form a partnership. Next slide. This is the general partnership versus the limited partnership. The key difference is that here, Juan is only putting the capital contributions to the partnership at risk when they make their investment. In other words, your investment is made, you may lose that investment, but creditors of the entity should not be able to come after you. The limited partners, the general partners in that limited partnership have unlimited liability. In the general partnership, all the partners have unlimited liability and exposure. Next. So we've talked a little bit about the limited liability company. Again, owners of the members, the business entity is formed separate from its owners. Limited liability of the owners for the debts and obligations of the business. Tremendous flexibility in organizing the operations. It's a hybrid of the corporation and the partnership with limited liability, but pass-through tax treatment. There's no tax at the entity level other than franchise taxes, but there's no income tax at the franchise tax level. And again, all members, personal assets are shielded from the debts and obligations of the LLC. It's important in LLC. We'll talk about corporations as well, that you adhere to formalities. And one of the key formalities is that you don't intermingle bank accounts. The entity, the LLC in this case, should have a separate bank account from the individual owners of the LLC. If you have a single member LLC owned by one member and you're commingling bank accounts, you can form this entity. You can form the entity, and you think you protected yourself, but what can happen is that the shield can be broken, and a third party that wants to sue the entity can say, look, we're gonna pierce the veil here. This entity really wasn't a separate entity. It wasn't operated as a separate entity. It was the alter ego of the individual. And so the LLC, we should ignore that form, and we're going to go after the individual owner of the LLC. And as evidence of that, they don't even have a separate bank account. Next slide. Oh, and I just mentioned that the LLCs are limited and that there's certain businesses that they can't engage in depending on the state law. Typically, a law firm, for example, my firm could not be an LLC. Professional services firms, insurance companies, banking, and certain other areas, the LLC can't serve as the vehicle. Next one. Next slide. Again, no limit on numbers or types of members. You can have hundreds of members in an LLC, subject to securities laws, different issue. And you can have corporations could be members of the LLC. So there's a tremendous amount of flexibility in who can own and how an LLC is managed. Typically, all of those issues are covered in what's called an LLC agreement or an operating agreement that kind of sets forth the governance of the LLC. Next slide. LLCs are typically the general benefit is that it's a flow-through tax treatment, a pass-through taxation entity. So you don't pay, there's no taxes at the entity level. but there's taxes at the individual manager level, or member level, I should say, based on ownership percentages in the LLC. Now, there is the ability for an LLC, and there can be circumstances, which I won't go into at this point in time, where it makes sense for an LLC to check the box to elect treatment as a corporation rather than as a pass-through entity. And so, again, you have flexibility there to start off as a flow-through, pass-through taxation entity, and down the line change by checking the box. So we can go to the next slide. The LLC, does have a minimum of $800 annual franchise tax in California. So that's why sometimes I run into folks that say, I'm not going to form an LLC. I'm going to remain a sole proprietor for now. I don't want to pay $800 a year. And then down the line, when my business is bigger and I'm concerned about exposure, then I'll start to pay the $800 minimum franchise tax, and typically tens of dollars or hundreds of dollars rather than thousands of dollars of filing fees. And then we've got a corporation. I see there's all kinds of questions popping up on the chat, which when we get to the end of this section, we'll try to address as many as we can. Corporations, again, separate entity. Owners should have limited liability, or should be shielded from liability for the debts of the business, unless there's something that results in piercing of the veil, of the corporate veil. Same as in an LLC. In terms of management and ownership, corporations have a little bit more definition to them. There's typically different levels. There's shareholders, the owners of the corporation. Corporations form a board of directors, which LLCs don't always need to do. And then there are officers of the corporation that are appointed by the board of directors. The corporations have less flexibility to allocate profits and distributions. The governance in a corporation is set forth in the corporation's bylaws. There's a document called the charter that is filed with the state to form the entity. And depending on the entity, there may be more or less detail in that charter, but a lot of the nuts and bolts mechanics are set forth in the bylaws. In the corporate entity, one person can hold multiple positions. One person can be the director, can be the director and the president and the secretary. There's flexibility there. There's no, unlike in the context of a partnership where the partnership agreement will determine the life of the partnership. So it or an LLC might terminate in 20 or 30 or 40 years. Corporations have perpetual life. Corporations provide for greater and more easy transferability of equity interest called shares of stock. In terms of equity incentives, incentive stock options are available in the corporate context, not available in certain other types of entities. And typically, venture capitalists and certain other types of outside investors would prefer to invest in a corporate structure than in an LLC structure or other partnership type structure for an operating business. And there's a number of reasons potentially for that. Some might be tax, but just in general, venture capital investors, for example, like to have their entities in a form in which they invest in a form that provides most flexibility for an exit transaction, for an initial public offering, an IPO, which really you can only do out of corporate structure, except in the context of certain complex IPO structures called Up-Cs, which we won't get into now. But generally, the corporate structure facilitates an IPO. The corporate structure facilitates tax-free reorganization transactions, tax-free mergers for an acquiring company that issues stock to the holders in the entity. And so as a result, when you get to the venture capital stage, if you started off as an LLC, you at that point, the VC that's going to invest might say, we need you to convert to a corporation before we put our money in. And that conversion is not overly difficult. So, to hopefully to anticipate questions that people may have. You can move around from these structures. Typically, you move from the top of our chart to the bottom. It's much more difficult to start as a corporation and then try to move your corporation to a limited partnership or a limited liability company. Next slide. So we talked about the corporate entities. There's two different types of corporate entities. They're both the same mechanically. You file with the Secretary of State of Delaware or California to form the entity. But the distinction between a C corporation and an S corporation is tax treatment. And an S corporation is simply a corporation, a C corporation, that decides to file an election with the IRS and to be treated as an S corp, which is passed through taxation from a federal perspective. The C corporation, the standard corporation, has double taxation, which means the C corporation entity is taxed, and then when the C corporation dividends money up to its shareholders, or there's a liquidation of the C corporation through a merger or otherwise, there's a second level of tax to the individuals. And there's been a lot of talk about what's happened in the last election and what may or may not happen in the state of Georgia. But it's safe to say that we have a number of clients that are looking very carefully at what might happen to the tax code, because there's all kinds of different ramifications if the Biden tax plan, as he's discussed and proposed it, is ultimately enacted, whether it's effective January 1st, 21, January 1st, 22, versus the current, kind of the current tax scheme in place now. So choosing the appropriate state of incorporation is kind of follows up on a question raised earlier. There's corporation law considerations, and then there's franchise taxes and filing fees. From a franchise tax and filing fee perspective, nice to be incorporated in the entity, in the jurisdiction where you're operating. From a corporate law perspective, though, it may be preferable if you can absorb without too much paying the additional franchise taxes to form in a place like Delaware that has a very well-defined corporation law, that has a court called the Delaware Chancery Court that does nothing but hear cases about Delaware corporate law. So these folks are obviously well versed in corporate law issues, as opposed to a judge or a jury you might get in California, where it's a little bit more of a crapshoot. But the Delaware Corporation Code, very well formulated. The case law in Delaware, very extensive. So for people that are looking for extensive case law, well-settled case law that they can rely on as they operate their corporation going forward, and that's one of the reasons the VCs like Delaware. They'll want to form in Delaware. I saw a question pop up about where do most major U.S. corporations form, and most major U.S. corporations I guess it was two questions. One was where they form. I would say a lot, the majority form in Delaware. The other question is, are they C corporations or S corporations? They're C corporations. We'll get into S corporations have significant limitations on who can be a shareholder, including that, and it has to be individual shareholders that are in the U.S. So if a company is going to have, shareholders from non-U.S. jurisdictions or any corporate shareholders, which most major U.S. corporations have corporate shareholders or entity level shareholders, the S corporation status is lost. Next slide, please. Which one is better? It depends. Next slide. So here's what I was talking about a little bit just now. C corporation, no limit on the number of shareholders, no restrictions. You can issue different classes of stock. So you can have preferred stock where the holders have preferences on dividends or liquidation preferences. C corporations managed by a board, limited liability to the holders, very easy to expand and scale, but very clearly double taxation. S corporation, you form the S corporation, again, it's the same way you form a C corporation. The entity becomes an S corporation simply by making an election to the under the IRC, under the Internal Revenue Code. But once you blow any of these restrictions, you simply lose your S corporation status. So if you go beyond 100 shareholders, if you try to introduce more than one class of stock, if you are bring in a shareholder that's a non-U.S. citizen, if you bring in a shareholder who's not an actual person, but as a business entity, those will blow the S corporation status. S corporations, like C corporations, are managed by a board. Again, limited liability, inures to the benefit of the shareholders, assuming appropriate corporate formalities are maintained. But you have these limitations. So there's a limit. As a practical matter, there's only so much you can do with an S corporation, and most major U.S. companies would blow through these requirements and become a C corporation automatically. Next slide. Again, taxes here. C corporation, double taxation. Once you tax once at the entity level on the business income at the level, and then at the entity level, and then taxed again on dividends. So for early stages, it might make sense of a company. It might make sense to avoid the C corp. The other issue is that your losses, if you're losing money, the losses are trapped inside that C corporation as well. So unlike a flow-through tax treatment entity like a LLC or a partnership, in which the losses go, run up to the individual owners, the C corp losses are not or cannot run up through the corporation to the individual owner. So unless forced to be a C corp by some other considerations, it makes sense to start off often as in the partnership or LLC form. Again, double taxation of the C corp, pass-through taxation for sole proprietorships, general partnerships, limited partnerships, LLCs, and S corps. Before deciding ultimately what type of entity to form, you want to make sure, because every circumstance is a bit different, and you want to make sure you talk to an attorney or an accountant about your specific circumstance. We're just talking about general principles in this presentation. Next slide. Again, to maintain a limited liability for the entities where that's relevant, like a limited liability company, like a C corporation or an S corporation, important to observe corporate formalities, important to keep bank accounts and other assets of the business separate from bank accounts and other assets from your personal life, so that you can and the corporate formalities that I'm talking about are, have a board meeting every year, at least once a year, have a shareholders meeting, paper all of that, so it looks like you're operating an entity that's separate from just the individual who's running it. And then to the extent that you don't have limited liability because you're operating through a sole proprietorship or a general partnership, consider insurance, and I would say strongly consider insurance. Obtain insurance would be the better advice, probably. In terms of the documentation, important on all these entities to know at the front end, when you have multiple potential owners and you're going to have employees involved, who owns what percentage of the company, how is it expected to change over time, and based on what? For employees, what's the expectation in terms of incentives? Is it going to be just cash payments, or are there going to be equity incentives to attract employees and to retain employees? So to the extent that employees are going to receive ownership, in what form is that ownership? Does it vest over time? Does it vest based just on time or based on achievement of certain milestones? Is the equity holder and the entity contributing cash, and so they get the full benefit of ownership right away? Are they contributing their time or other resources? If they're contributing their time, then they probably don't get full benefit of ownership right away unless until they've spent the time that merits the equity ownership. It's important to clarify who's got what responsibilities in the company and to formalize management relationships. It's somewhat easy in the context of a corporation. There's a board of directors. It's pretty clear that the board of directors is responsible for overseeing management of the company. That board will appoint officers, and the kind of the clear delineation of power and structure in the LLC or partnership context. It's much more important to make sure, if there's not that kind of clear chain of command, it's much more important to make sure you've indicated on a sheet of paper who's responsible for what types of decisions in the company. Next slide, please. So this slide shows, and it's a very useful slide. I don't know if I'm going to walk through each box here, but it gives specifics on the filing fees involved in each different type of entity. These are California numbers. But you know, if you're a sole proprietorship, you can see there's no state franchise tax, right? You have a fictitious name statement filing at the front end, but you avoid all these other fees. In any other type of entity, an LLC, a C or S corporation, or a limited partnership, there's a minimum $800 annual franchise tax fee. And then every year for LLCs and corporations, you have to file a statement of information. And the filing fee is the upfront fee. So, you know, $70, $100 to make a filing with the Secretary of State to form these entities. So you can see that, you know, you can see the distinction in terms of, you know, quantification for a quantification of the, you know, kind of the ancillary fees, the, you know, fees that need to be filed. And you can also see that they tend to be more extensive the more limited liability, the more liability is limited. So the limited partnership is $800, LLC $800 plus an LLC fee, C corporation $800 plus a 9% you know, net income, a tax on net income. And here's how the corporate the income tax is determined. Sole proprietorship, you can see it's just the owner's form 1040, individual tax. Use of losses can use to offset individuals' taxes. No issue about distribution to owner because there is the owner, there is no entity to make a distribution. The LLC, again, flow through on income and expenses to the partners and the members. I'm sorry, probably. Yeah. And you know, distributions to owners are generally non-taxable to the extent of their basis in the LLC. And then you can say C corporation actually pays taxes on profits. So when the shareholders, you know, take the profits that are after-tax profits from the C corporation, the distributions are then taxable dividends. Corporate tax rate, you know, you can see the corporate tax rate that may move depending on what happens with our tax code and the political situation in 2021 and 2022. And then distributions to owners, not deductible by the corporation. It's generally, you know, those dividends would not be deductible. Let's see a question: what category would nonprofits be into? Nonprofits are a type of corporation generally that's formed under the state law, but that will not, you know, will not have a tax imposed on it because it, by definition, is not is a nonprofit entity. Now, you can end up, if you're a nonprofit tax exempt, then you will be entirely tax, and the nonprofit tax exempt is basically a nonprofit corporation formed under a state law, including California, that then makes a filing with the IRS, and if the filing is successful, it receives tax exempt status, and there's no tax. Nonprofits generally don't have significant profits. If they do, they will, you know, apply for tax exempt status. If they don't, the nonprofit can potentially be taxable, but most of the time, what happens with young or startup young nonprofits is all of the revenue that comes in is paid out in salaries, paid out in expenses. So there's nothing left there to tax. But a nonprofit, in terms of the category, is typically a corporation structure as opposed to a LLC or a limited partnership. And then again, the S corporation, just on this chart, is taxed the same as an LLC. The income and losses flow through to the individual shareholders. Next slide. And this deals with sole proprietorship. This deals with each of the entities, and we talked earlier about self-employment taxes, and you can see the fringe benefits. In the sole proprietorship, amounts paid are generally not deductible. Fringe benefits for the LLC, amounts paid on behalf of partners must be included in the partner's income. For the C corporation, owner employees are entitled to the same tax-free fringe benefits as other employees. And you can see there's a limitation with respect to the S Corp with respect to fringe benefits. Okay, next. So the breakdown, general breakdown of entity types is just kind of we've gone through, this already, but, here are some of the basics. LLCs can have one or more owners. Limited partnerships by definition will have multiple owners. And for LLCs, you can have owners manage, or the owners can designate a board of managers to manage. Either way, limited liability. Fewer legal formalities, pass-through taxation, limited partnerships. Again, the partners, the general partners manage. At least one of the partners is a general partner that's going to have liability. At least one of the partners is going to be a limited partner that doesn't have liability. By definition, a limited partnership has to have both general partner and a limited partner, at least one of each. We talked about C corporation, no limitation on the number of shareholders, limited liability, easy to expand, double taxation. S corporation can't have foreign shareholders, can't have more than 100, can't have any, have to be natural persons. In both cases, there's a board of directors to manage the C corporation and the S corporation. Okay, next slide. Limited partnerships. I think that was meant to be limited liability partnerships would be generally for specialized professional groups. Well, I shouldn't say that. Limited liability partnerships would be for lawyers. Limited partnerships are typically formed generally for funds, investment funds, whether it's real estate, venture capital, private equity. You have a general partner that kind of manages it, takes a share of carry, like 20% of the profits for managing it, and the other 80% go to the limited partners who've invested their cash. C corps, as I mentioned before, generally used if the entity is going to receive VC or investor funding. It's easily scaled, easy to grow a C corp. You can take it public easily. It can be sold in a tax-free reorg or other transaction easily. LLCs, very popular, flexible tax structure, can be individuals or entity owners, and some companies live their entire lives as LLCs and can be sold as LLCs. If VCs will oftentimes be reluctant to invest, and then the S corp is the same thing as a C corp, except for the tax benefits of having the single level of tax. Next. Talk a little bit on cooperatives, and we can, if there's questions on this, we can drill down further. But basically, a cooperative is a organization that's jointly owned and democratically controlled for the benefit of its members, which is other than for profit. Typically, the mutual benefits referred to here in this slide are mutual benefits in terms of a supply arrangement, a marketing arrangement, a service arrangement, a community, workers co-op. So it's one vote, one man, one vote, one woman, one vote, and it's democratically controlled in that way. You don't have major investors that have a controlling interest that kind of determine the organization's direction, but it's jointly owned by the people that are participating and working in it. So California law has, in different states have different rules around cooperatives, but California law does specifically prescribe, has a statute for cooperative corporations, and there's no limitation on numbers of owners or members. Everybody under the California statute has one vote, as I mentioned earlier. It's pure democracy. There's no controlling members, if you will. Managers, there could be separate managers that manage it, or it could be members that manage it. These are corporations, so there's limited liability. The owners or members, if you will, don't have liability as such for the problems in the entity. Like a for-profit, regular corporation, C corporation, typically the corporate formalities and the corporate governance mechanics are set forth in bylaws. Profits are taxed only at the entity level. There's not profits taxed. There's no profits that run upstream to the individuals, because basically benefits are distributed based on contribution to the entity, to the collaborative, not based on equity ownership. And owners are generally considered employees, and so you need to think about that in the context of, if you're looking at doing a cooperative. There's benefits and detriments potentially to that, filing as a cooperative corporation versus an LLC, and that could include, do you have people that are going to be working there that you have problems viewing as employees for immigration or other reasons? Well, that's entities, and we took a good amount of time on that, and I know there were a lot of questions that many of which I didn't get to or didn't see. Is there anyone that wants to ask anything now before we get on to, we'll spend a few minutes on licensing and permits, not too much time.
Thank you, Mark. I noticed that we have, yeah, you're right. We have a lot of questions here. So for those, you posted some questions. If you would like to ask them, you can unmute yourself.
Mark, I have a quick question on limited liability partnerships.
Yes.
I was curious, is it possible to negotiate with your partnership that says that the general partner can make all of the executive decisions without the limited partner's input, to where you can have one partner have controlling, or are partnerships always going to have people have equal say based off their equity or some other negotiated metric?
You're talking about limited partnerships rather than limited liability partnerships, right? You're talking about limited partnerships.
No, I'm talking about I'm actually talking about an LLC formed with partners. I'm in a position where I'm bringing a person on board that I want to be the CEO of my company,
right.
But I don't want to make them. I started everything. I came up with everything. I would still like to be the person who generally is in charge. So is there a way to make yourself the partner who can make certain decisions, and then they can come in under certain circumstances? If that makes sense.
Sure. Well, in terms of an LLC, you could. I mean, there's a tremendous amount of flexibility. So it really, you can run the gamut. If they're not going to own equity, then they're simply an employee, an executive, and you would enter into an employment contract with them. If they're going to own equity, then it depends on the type of equity and what percentage of the company. But certainly, you as the majority owner and the founder can control basically everything. You can point yourself. So anything that the company does can be subject to your approval. As a practical matter, presumably the person you're bringing on is going to have some flexibility to do, certainly if they need to buy a couple pencils, they can do that without your control or without your consent. But you can kind of manage that as tightly as you want to and as tightly as is practical. So you don't. First of all, you can bring someone on in an LLC context who's not a member, doesn't own any of the equity, or you can bring them on as a member that owns equity but doesn't own as much as you, so you can always outvote them, or owns equity of a different type that you own that could be non-voting. There's a lot of flexibility in the LLC context, as there is in the partnership context.
Interesting. I didn't realize there was a non-voting equity. Thank you for that insight. I really appreciate what you've said so far. I really appreciate you. Thank you.
Yeah. Certainly you can have non-voting equity for sure.
Thank you, Mark and Donald. So we can move to Maher. Maher, you have I guess, a couple of questions.
Yeah, I do. Hi, everybody. So for just sole proprietorship, can we have an FBN registered in a county and operate in other counties? And can we calculate the taxes by ourselves?
Well, yes. I mean, it's the last question first. You can calculate the taxes by yourself. I mean, you have to think about, are you going to have employees, or is it simply you're just running it by yourself with no employees? But you know, whether you hire an accountant or not depends on your ability to calculate the taxes. But certainly, you know, some sole proprietorships do all the paperwork on their own. Yeah, in terms of filings required in different counties, you typically would file a fictitious business name statement with the state. You know, depending on, you know, this goes to the licensing and permits. You may need, depending on what you're doing as a sole proprietorship, you may need to make filings in, you know, different counties. But it's a local question, so it depends on what you're doing in those counties. If you're opening up, you know, restaurants in multiple different counties in the state, then you're probably going to need to do, you know, filings and get permits in each of those different, you know, for each of those different counties.
Okay, thank you. I appreciate it. I just have another quick question, if it's possible.
Sure.
So it's about what should be the considerations to register a corporation for online services that operates in the US and eventually other countries? Should we consider like the international laws or like the local laws, or just care about the US law? Or
well, in terms of the entity and the formation and operation and governance of the entity, that's, you know, kind of a US law question. I mean, you know, setting aside, you know, tax jurisdictions and whether you want to, you know, get out of the US and, you know, go to the Caymans or something for that type of an entity, you know, depending on what, you know, what the regulatory structure is or regulatory requirements are vis-a-vis the entity. Otherwise, you could form the entity in the US. And then, you know, in terms of operating the business internationally, if it's online, it you know, depends on what the business is, but, you know, most online businesses you can form in the US and operate online in other countries. And then the question is, you know, are you going to have to get any approvals, or you know, or different countries going to cut you off depending on what you're doing online, you know, based on whether you have you know, local approvals or not. But many online businesses that operate in Canada and Mexico and Europe are formed in the US and operate without a whole lot of restrictions, you know, beyond that which is, you know, related to the governance in the US.
okay, thank you so much. Thank you.
I have a question. Can we go back one slide? I just wanted to go over the co-op.
Yes.
Thank you. So do I understand correctly that, so for the co-op, one of the reasons why you might want to do this is to basically give a sense of that all the owners like have a stake in, because they're an owner, right? So it's a cooperative, right? So then they all have a stake in it. So that's why that's a good thing to do. But then it says they're typically considered as employees. So does that mean when it comes to benefits that, you know, as a company, you have to provide health insurance, like 401k, that kind of stuff, or how?
Yeah, that is a potential issue. Is that if you're looking at, you know, if you're looking for flexibility, and really the choices between making, you know, doing a co-op as a corporation or doing a co-op as an LLC, essentially. And if you do the co-op as an LLC and you've got all the participants are effectively members, you know, owners of the LLC, you might be able to avoid treatment of those individuals as employees, and because they're LLC owners. But in the co-op formulation, owners, whether they're owners or not, they would generally be considered employees. So that has implications for insurance. It has implications for, you know, immigration issues that don't necessarily exist in the context of the LLC. But to be clear, the co-op in general is for the benefit of the owners, but it's not an economic benefit. It's not a profit benefit. It's a benefit because they share the same, you know, supply arrangements. They share, you know, there's a kind of a common service that is being provided or delivered that they can do better together than separately. And so there's not really a profit benefit in the context of the co-op. The benefit comes in the context of whatever activity the co-op is engaged in.
Okay, thank you.
Should we move on to permits, and then maybe we can come back to some of the other questions?
Actually, I do have a question too.
Sure.
Given what you have just said, my situation is similar to the following scenario. There was a story I saw on TV about this guy who made these little toys. He just made little toys. And his parents really were annoyed at the fact that he wasn't getting a real job.
Okay.
And all he did was made these little toys. Well, maybe a year or two later, McDonald's approached him. And he ended up getting a huge monetary deal for his little toys, and they started using them for Happy Meals. So for someone like him, is he going to file as one of these corporations or LLCs or whatever? I mean, or is he just going to be like a sole proprietor or something?
Well, at that stage, it probably doesn't matter. If McDonald's has already purchased his business, right?
I guess so. So I guess that's sort of going into what you're about to talk next, which is licensing and.
Well, so whatever the deal was, I mean, at this point, presumably he's either sold to McDonald's for cash, or he, as you say, he's got some kind of a licensing arrangement. The next topic is not so much that type of licensing, but rather permits for a business. The time to do the planning would have been in advance of that happening. But he doesn't need to form a corporation now because presumably he's got all the cash and from that sale, and so things worked out okay for him. And as long as he doesn't get sued for anything that happened when he was a sole proprietor, then he should be, he's probably happy that he never, entered into any of the complicated, filings or anything like that to shield from liability, because he's already out from under, and he's made a bunch of money.
So would he could he conceivably get a deal from McDonald's, like for not just licensing because it's his invention, but also
they could buy his, they could buy, he, and I don't know whether he had patents on the invention or not, but presumably McDonald's bought the rights from him to his invention. And so, and that could be, they could pay him in cash, they could pay him in royalties going forward. They could pay him in McDonald's equity. I don't know anything about the deal, but right. There's all kinds of different ways to structure it. But at this point, he probably doesn't. It's not as important to him now whether he's a sole proprietorship or a corporation or an LLC, because he's already done his exit, if you will.
So he wouldn't have to worry about doing any of this stuff.
Well, he should have. In general, it's good to worry about this stuff because you don't know that you're going to be bought out by McDonald's in a year with whatever business that you've got, and so you have to plan, accordingly, and not assuming that you're going to get bought out. But yeah, if you know that you're going to invent something, and in a year it's going to be purchased by McDonald's, and you're never going to sell it or have any exposure in advance of that purchase by McDonald's, then not much to worry about in terms of all these other issues.
So if he were not purchased by McDonald's, what would have been his best bet to?
Well, if he wanted to start selling these toys to monetize his business, then his best bet would have been to form an entity that could then sell the toys without concerns that some kid, some baby's going to choke on one of them and he's going to get personally sued. But form an entity, capitalize that entity, just bring in investors or not, depending on whether you think you need to scale, and depending on how the entity would not be a cooperative for sure. It would be a for-profit entity, whether it's an LLC or a C corporation, and run your business that way. And maybe you hire again, if he wants to be a lone ranger, he can subcontract out all the services and he has to pay for that, pay the subcontractors their fees, or you can hire employees. I mean, there's all kinds of ways so it's hard to say for sure what's the best way. It depends on what your plan is to get to a liquidity event. But normally you don't form a business and then 1 year later have a big liquidity event. That's good fortune. I don't know. Hopefully, I answered the question. Maybe not, but
Yeah, you did.
I gave. Earlier we talked about some of the benefits and detriments of the different types of entities that you might want to form to operate a business in, and all those factors should be considered at the front end by a company, by an individual who's starting a business.
Thank you.
Thank you.
So just a minute or two on licenses and permits. I mean, basically, this is kind of a checklist of what you should be thinking about in terms of your business, and depending on what the activity is, things may or may not be, may be more streamlined than for other activities. So you've got local, state, and federal level, and so the things you need to think about when forming a business, at the local level is where am I operating the business? Is it going to be out of my home? Am I going to have a separate office? Is there going to be any manufacturing? Am I going to be, selling food? Am I going to have rock bands playing in my business? So zoning issues are among the issues. Then you have fictitious business name filings, which are DBAs, which are both federal and potentially local issues. If you're a sole proprietorship, as we talked about before, if you're a corporation or an LLC, you'll have the name of an entity that you'll use. But if you're a sole proprietorship, you probably won't be using your own personal name. You'll probably have a business name, and so which is a kind of a doing business as concept. And so you would make filings at the county level and potentially at the state level. And then there's business taxes at the local level, and you have to think about, again, whether there's other permits or licenses depending on the type of business. If you're undertaking an activity that's going to throw off hazardous waste, that's going to be a little bit more complicated from a permit licensing perspective, than if you're selling lemonade on the corner. Then at the state level, you've got, again, permits. You need to qualify to do business in the state if you're not formed in the state. So that gets to, if you're going to organize in Delaware but be operating in California, you're going to need to be qualified to do business in California separately. There's obviously tax, insurance, and withholding issues. Employer, if you're going to have employees, really to form the entity, you need to have and open a bank account. You're going to need to have an employer identification number, workers' comp and licenses issues. And then at the federal level, you've got, taxes and withholding to think about. But I think that the key issue at the front end is what's the business engaging in, and where is the business going to be taking place. And then you once you've got that laid out, at least in terms of the initial plans, then you can think about what permits are going to be needed, what zoning restrictions you're going to face at the local level, and depending on how many employees you're going to have, that'll determine workers' comp issues and the like. So this is a little bit of a checklist for things that you should be thinking about. But in terms of what applies and what doesn't, and the magnitude of that, it's going to depend on the type of business you're running. Should we go to contracts?
Yes.
Okay. We can go to the next slide. We'll talk now a little bit about the importance of contracts in businesses, basically in a business. And I'm a lawyer, so I may be self-interested, but I am a big believer in crafting clear contracts. It may be somewhat painful at the front end to do it, but it usually saves, it often saves a much greater degree of pain and expense down the road. So just in general, a contract is a promise or a set of promises that can be enforced in a court of law. And that, generally, preferably is a written contract, but it can also be an oral contract. If two parties don't have a written contract, but one makes a promise to the other and is aware that the other is acting in reliance on that oral promise, then an oral promise can be enforceable in court. And so, in order to protect against misunderstandings created by, oral discussions that arguably may be deemed to be promises, it's best to lay it all down in writing. Best practice to have business contracts in writing. I'm glad that is double starred and in bright red there. Next slide. So, why a written contract? One, it's easier to establish the content of the agreement, right? It's all done on paper. If you're talking about an oral agreement that, it's not on paper, who said what to whom when, was that what was intended? It's she said scenario where one party says that's what was said and another party says that wasn't. You put it in writing, both parties sign it, pretty easy to prove the contract, the contents of the contract. That doesn't mean there won't be disputes down the road, because even if you put a contract in writing, there may be ambiguities. There could still be issues that arise, but it's more likely to be clear in terms of the contents if it's in writing. It allows other parties to review the contract and to review the agreement, whether it's a bank that's interested in, that's going to loan some money, that's interested in seeing what's in writing, or a landlord or someone else. Others can review it, then also potentially a court. And then it's clear that there was an intent to enter into the contract because the contract was signed by both parties. Whereas if you don't have a signed contract, that can be in question. One party thinks it was clear there was a contract based on an oral discussion, the other does not. So, next slide, please. Areas to use informal contracts. If you've got a professional services business or a business where you've got clients, certainly contracts with the client should be signed. We have, anytime I sign up a new contract, I've got an engagement letter with my client. Vendors, to the extent that there's a sales contract for materials, purchase agreements, clearly, that involves presumably a meaningful amount of cash exchanging hands, and these sales contracts there should be contracts. Employees, you don't need long drawn out employment agreements for each employee. For rank and file employees, it may be simply a 1 or 2 page offer letter that basically doesn't say much more than you're going to be working for us, we're going to pay you every other week, and this is an at-will contract which we the employer can terminate at any time. It gets more complicated when you're talking about senior executives and employment agreements and the like, but having contracts with your employees that lay out in particular that they're at will is very important. And also, to the extent there's any technology involved in the business, getting an agreement from the employee to not disclose what's happening inside the business is important and should be routine. Independent contractors, it's important to have a written contract, because if you're treating someone as an independent contractor, you want to be very clear contractually that they're an independent contractor, so they might not be deemed to be an employee, which has ramifications. And so there's some buzzwords and important provisions that appear in independent contractor agreements. Those things should be in writing, so that you don't have the State Department coming after you later and saying these are really employees, or at least you have a better defense. Potential partners in your business, outside parties that you may engage in a joint venture with. Non-disclosure agreements are important. In the context of business entity formation, which we just talked about, you don't really need contracts for corporations, because those are handled through filings with the state and bylaws. But for partnerships, for LLC agreements, or for LLCs, you need to have an agreement in place. LLC, it's called an operating agreement. Partnership agreement for partnerships. And then for capital providers, if it's a lender, there'll be clearly credit agreements, and the lender will insist on that. And if there's equity involved and there's preferred rights in that equity, there'll be contracts that evidence that as well. Next. So at a minimum, the contract should clearly describe both parties' obligations, what the payment terms are, what the time frames are for delivery of goods, services, and for payments, and in terms of extensions and the like, or grace periods for payments. And then there should be a time frame as discussed in the next bullet here, for termination. When does the contract terminate? You typically do not want to have open-ended contracts without a termination date, or if it's not a specific date, an event that results in the termination of the contract. And then it's good to lay out how how disputes that might arise in connection with the contracts or the services or the payments called for under the contracts, how are any disputes going to be resolved? Can either party go to court, and you might end up in front of a jury in California that doesn't have a whole lot of background in the substantive area around the contract? Or do you want to be more specific about where the disputes can be received, can be heard, and whether those disputes can only be heard in the context of an arbitration, for example. And then, in the context of dispute resolutions, how reliable, how much guidance are you going to give the party resolving dispute, whether it's a court or an arbitrator, as to how liability should be apportioned, who pays the cost of disputes. Those types of things all can be and should be in a well-written contract. And then, once you've got a contract that someone provides you, or that your lawyer provides you to provide to a third party, read it carefully, and then sit back and think, can I live with these terms? Is there anything I need to change in terms of, or anything that I should change in terms of what's being offered? And think through yourself, or with the help of an attorney, what the implications are of the contract you're about to sign. Next. Just a couple of additional elements. Not all promises are enforceable as contracts. You want to make sure the contract is a legal contract. It's not there's not deficiencies in what you think is a contract that makes it unenforceable. Always important to beyond the moral issues, from a legal perspective, it's important to not be misrepresenting facts that could lead to misunderstandings of the contract, or that could lead to someone saying that they were fraudulently induced to enter into a contract. Realize that once you enter into the contract with a third party, it's I certainly run across people that say, well, we thought we could live with that, and then if there was if circumstances changed, the other side would be reasonable and we could work out a change. That's not necessarily the case. I mean, when you agree to the contract, think about, you have to live within its terms, and that any modification, whether you think you're friendly with the other side or not, is going to require an amendment and potentially a new exchange. If you're asking for A, the other party may ask for B in exchange for A. Offers that are made, that are unilateral offers, you need to understand the time frame for acceptance. Sometimes within the offer, we see this in mergers and acquisitions from time to time, letters of intent. The offeror the acquirer will say, this offer is good until Tuesday at midnight. And so realize that if you respond on Wednesday, the initial offer may not still be there. Try to, in the contract, avoid ambiguity, make sure to read the contract. And then if you're in a contract and the other side has technically not performing some requirement, maybe a notice requirement, but is still substantially performing under the contract and not a material breach, at your own peril, you'll stop performing. You should really continue to perform, and only if the other party is in material breach, rendering the contract useless to you or of much less value to you, are you justified in stopping performance? Because unless if the other side doesn't perform and you stop performing, not only are they in breach, you're also in breach. And so you need to follow the contract, what's prescribed under the contract in terms of dispute resolution, in terms of remedies if the other party breaches, and make sure you don't just stop performing, because it could cause a bigger problem than you might otherwise have. Next slide, please. Use formal contracts. These are tips if you want to have a healthy business going forward, and there's no guarantee that any business is going to be healthy, but certainly it's helpful to make sure that all people you do business with, you have a formal contract around that. It doesn't mean it needs to be a 40-pager, but setting out the terms that we talked about before is important. And keep good records. This is helpful in terms of running the business. It's also helpful. We talked before about corporations not getting their veil pierced, maintaining corporate formalities. Having a good records keeping system. Making sure that you've got records for payments to and from the business. That you've got proof that to the extent there's deliveries that need to be made and there's receipts, etc. Proof that you perform the contract. Retaining that proof is very important. And then on employee issues, you want to document issues with your employees. It can be very easy that with an employee that's performing at about the middling range to kind of gloss over things and keep the employee and say everything's great, you're doing a great job in order to keep the employee around. But then 6 months later you decide that middling performance is not adequate. Well, it would have been good to document at the earlier stage problems with the employee if you're trying to, for example, terminate for cause, or you're trying to avoid a discrimination claim back at you for an employee termination, whether it's age, gender, race, whatever it is. If there's problems with the employee performance, it's important to document those and be frank about those earlier rather than later. Next slide, please. Okay, maybe let's stop there. Anything further on contracts or on anything further on contracts?
Question about contracts, maybe a bit of a silly question, but so you explained about the oral and written contracts, and if it's a written contract, like how official does it have to be? Because you see in movies all the time, oh, you're chatting with a friend and you write down on a piece of paper or back of a napkin. Is that considered as a strong enough contract, like if you have that written agreement? Or
it can be. The problem is you could certainly have a napkin that's written on, that's initialed by two parties, that can be deemed a contract, and that's one step further than just having an oral contract. But the problem with a napkin is you can only get so much detail on there, and so you may have a back of the napkin contract that's ultimately deemed enforceable, but that may be problematic for one side or the other because it doesn't deal with that side's all the concerns that side may have. So it's really hard to lay out in a napkin or back of a napkin, or all the different kind of time frames for deliveries and for payments. It's hard to lay out the bases on which one party can terminate the contract. It's hard to lay out if there's a dispute, you want that dispute to be in arbitration rather than in a California court. So you can certainly have a back of the napkin that's enforceable as a contract. It's just not it's not advisable. It may be better than just an oral contract, because at least you have something on paper, but it could also backfire. So having something a little bit more formal is better. But contracts can be, the court can call it a piece of napkin or even an oral promise a contract, as described earlier.
Okay, so but you're saying that it's more the content, right? Because you're saying like if it's written down, then that is legally binding.
Yeah, it could be. I mean, it really depends. I mean, it depends what's written down. I mean, if it's so vague, so the question is really going to be whether a court would look at that and say it's clear that what the intent, from what's written on this napkin, it's clear what the intent of the parties are. And if that's the case, then a court may view that as a binding contract. But you don't need, in most cases, you don't need documents to be notarized in order to be formal enough to serve as a contract, and you don't need something to be 20 pages to be serve as a contract. So yeah, maybe answering your question more directly. Yeah, it's what the content is, and is it sufficiently clear as what the parties' respective intents are to form the basis for a contract that will determine whether that napkin writing was enforceable.
Thank you.
Thanks, Mark.
And, there are certain contracts that, real estate, mortgage deeds, and, you're talking about something that is more formal than just a 20-page written contract that's signed by both parties. Then you're talking about notarizations that are needed and the like. So it depends on the type of contract as to how, whether or not, additional formal, you can't transfer real estate on the back of a napkin.
Thanks, Mark. I see that we have some other questions from various people, but I was wondering if, in the interest of time, maybe we can go on and cover IP and then get to the questions later if there's time at the end, or if...
Yeah, that's fine with me. We can run through the IP issues, the IP slides quickly, and then take any questions. Next slide. Okay, so intellectual property, depending on the business, could be extremely, extremely important, or could just be important. But typically, there's some element of intellectual property that's going to be important to your business, because even if you don't have a high-tech business or a biotech business, you might want to protect your name. You probably almost always do. You want to protect company information. You want to protect your brand. So you protect names, brands, company information, inventions through one or more of the following on this slide. Trademarks, those relate to, and trademarks are, can be anything from something that is, proprietary but not filed, to something that you file to protect with the U.S. Patent and Trademark Office. But business names, slogans, logos, those are the types of things that you would, protect, that there would be trademarks that you might want to protect. Copyrights, a little bit different. The law around software, oftentimes software can be difficult to patent, but certainly software code, artistic creations, books, poems, artistic works are copyrighted and should be copyrighted through designations, if nothing else, on the work. Trade secrets, this is broader. You're not necessarily making filings with respect to trade secrets, but the company may have, your company may have any of a number of trade secrets that have some value, even if it's not patentable, even if it's not a trademark for which you can file. But customer lists, supplier lists, pricing issues, those all may be trade secrets that are protectable, and that you can, and that that if someone comes and misappropriates those trade secrets, whether it's a former employee or a partner, that you as the company that has the trade secrets could seek a claim for. And then patents, relate to any of a number of patents. It could be design patents, process patents, but companies that have significant technology, significant inventions, will often go through the process of filing for patent protection. Bottom line is that whatever your IP rights are in your business, in your company, you want to do what you can to protect them, if to the extent that you think they have value to your business. Next slide. So a little more detail on trademarks. A unique name, a phrase, a design, a symbol that you're using to sell goods would be considered, something that would be a trademark, or could be a trademark available for your brand. Again, a name, phrase, or design used to identify, services or source of goods. And you've got some examples there with Nike, and you've got some very high-profile examples with the Nike logo, and Pizza Shack and McDonald's. And so these can include, as mentioned, slogans and logos, but also sounds, specific colors, specific scents. Those things can be trademarked. You can't use, you can't trademark, a generic descriptive like sugar cookies, because it's just too generic. That's not, you're not going to be able to, that isn't the same thing as I'm loving it by McDonald's from a trademark perspective. And then what you're doing when you, seek trademark protection is make sure that no one else can use that mark, that phrase, that symbol, that name, so long as you continue to use it. So, there's oftentimes tremendous value. Obviously, in the Nike logo, there's tremendous value, and Nike would want to protect that, not let other people use it and misuse it. So the way to obtain, or a way to obtain trademark protection is, typically do a trademark search with the U.S. Patent and Trademark Office. You can also check for available domain names in various states. And then you register. You can do this online. You could also do it through an attorney. Trademark, unlike patents, trademarks protection can be, filings can be, less expensive. In the hundreds of dollars as opposed to the thousands or tens of thousands of dollars. Enforcing trademarks, typically if someone is misusing your trademark or violating your trademark, you'd start with a letter saying stop, and then if necessary, you would proceed to litigation. Next, please. You want to beware of avoiding trademark infringement yourself. Or investing in a name or money that's or a symbol that's going to potentially violate someone else's trademark. The more money you invest, the more painful it is for you to cease and desist once they come after you. So beware using trademark or copyrighted artwork on your webpage, logos, or other materials. Electronic tags allow the trademark holders to track unauthorized uses of images. So doing a trademark search, if you're going to be investing something, if you're going to be investing a lot of money in a name or a design or a logo, check the trademark office first. You can, for free artwork, you can consider using Creative Commons. Should we go to the next page? So copyrights, we talked about a work of original authorship. Could be a movie, could be music, could be software. You don't copyright names or short phrases or general ideas that haven't yet been put down on paper. The copyright protection, though, if it's something that's merits copyright, work can generally protected for as you see, life of creator plus 70 years. Fair use exceptions. You use the copyright symbol, and if you file it online, it's not expensive at all. Next. Trade secrets. We talked about before. Companies' confidential information. It might not necessarily rise to patentable. Might not necessarily not be something that's trademarked, but if it's a client list, if it's a recipe, if it's engineering information, it's valuable, economically valuable information because it's secret, not generally known, and you've taken reasonable measures to keep it secret. Thus, it's a trade secret that you can protect by, through non-disclosure agreements. And ultimately, if someone's violating or breaching or misusing your trade secret, misappropriating your trade secret, you can sue them. It's generally a company's public information would not be considered a trade secret. Next slide. Patents. This is this is obviously you can see the drawings. Patents are available for inventions, basically, and typically new, non-obvious technical inventions, whether it's process, whether it's a drug, whether it's a machine, whether it's algorithm, sometimes can be patented, but not available for obvious inventions or software. And basically, if you file with the patent office, you can prevent anyone else for a long time from using your invention, but the invention will be public. Because the filings that you make with the U.S. Patent Office are public. You could file for provisional or non-provisional. This is kind of a strategic issue. A provisional application basically is a line in the sand. It's kind of a preliminary filing, and it's that application is good for a year. And at that you've got your stake down, and they're not that expensive to file. And you've got a year to flush it out. The non-provisional, a full-fledged application, is more expensive out of the gate. But once you file it, that's your full patent application. There's no 1 year tail on that that's available for 15 or 20 years. Patent law is extremely complex. You may be a great engineer, you may be a great draftsman in terms of being able to draw something, but you still strongly advise to seek counsel of a patent attorney if you're planning on going this route. Next. So you can see the timeline here, and it really depends on, these are some generalizations. It depends on the type of technology, but it can be, typically at the front end, it costs, thousands of dollars, maybe 10, 15, $20,000 to actually get the filing. That's for the non-provisional, that's for the full-fledged patent. And then you have, annual maintenance fees after that once the patent is issued. It's an involved process, and you really need, and then ultimately you have to recognize that the patent ultimately does expire, and so there's a long life but a limited life, and your information will all be public. So hopefully you've derived all the value and moved on to a follow-on invention by the time the patent timeline runs. Next slide, please. So considerations, costs, we talked about time, money. Your method is made public, and then ultimately it could be very costly to enforce the patent. The benefits, you have to think about why are you patenting this? Is there a real risk of losing business from copycats, or is it just good enough without a patent to be the first to the market, and you don't worry about kind of the patent protection at the back end? Does the risk outweigh the cost? The first inventor to file wins the dispute regarding the patent. Here's alternatives. I talked about a provisional application at the front end, a lower cost. You have 1 year to figure out ultimately if you would benefit from a full-fledged non-provisional patent and what that patent would say, and then you can in that 1 year period perhaps improve your funding for the full patent application and make a determination as to whether or not there's going to be a market out there to buy your product or license your invention after you file that provisional. So it's just kind of you're putting a stake in the sand. And then again, another alternative is to say, I'm going to keep, rather than file for a patent, I'm going to view my invention as a trade secret and keep it a secret. And if anyone violates that, the problem, of course, is if someone doesn't know about your secret and then does something that overlaps and takes your market away, you have no claim. Whereas in the context of a patent that's been filed, you might be able to claim a breach of the patent. Next. IP general tips, branding. You're early on. You want to, your corporate name, your entity name, any branding and logo. It's not that expensive to kind of protect this stuff. So think about these things early in your company's life cycle. Ownership. This is kind of dense here, but oftentimes think about if you're a founder of a business and you're forming a company. Is the founder going to, and oftentimes, the IP is held in the founder's name. It could be a patent application in the founder's name. Is that going to be contributed to the company, or is it going to be kept by the founder? Obviously, if it's contributed to the company then has more value. If the founder retains it and simply licenses it to the company may have less value to a subsequent investor. You need to think about those issues. Everyone that you work with, if you've got a company that has any technology at all, anybody that works with your company, whether it's an employee, a consultant, any kind of service provider, any kind of partner, you should get an assignment of inventions confidentiality agreement from those individuals, so that any time that they spend, once they've signed on as an employee to your company, and they go home that night, they can't take what you're doing and then make their own invention out of it. They're agreeing at the front end to assign to you everything that is made out of their efforts that relates to your business. And typically those, to the extent they've been developing something else on their own, they may try to carve that out from that assignment. But generally, if you're paying that employee $100,000 a year, whatever they do belongs to the company, and that's important. And the assignment should cover everything: and copyrights, trademarks, trade secrets, all inventions. You should all, There should be a confidentiality agreement that not only says you'll keep information confidential, employee or independent contractor, but you won't use it for any purpose other than to benefit and further the goals of the company. So those are some, and different states have different prohibitions and restrictions and issues on enforceability, particularly as it relates to non-competes and non-solicitations. So you want to think about those and be aware of those. California, for example, on non-competes is very tough on enforceability of non-competes. Generally, they're not enforceable in the absence of certain specific circumstances. You want to have company policies that are clear guidelines for all of your employees and others, that lays out how company resources and information should be used and protected. And then obviously think about your internet strategy and make sure you're protecting what you put on the website that you wouldn't want other people to be able to use. To be careful what you put on the website if it's not protected, would be the other way to say that. Anything else? Next. Okay, well, we've run out of time. So yeah, these next slides, for startup corporations, we can just flip through these, Tobias. I mean, there's, the types of documentation that you would typically use in a startup. I don't know if you want to just kind of rifle through these, Tobias, and then get to the next. We don't even have to talk about any of these. I think we, general considerations. We can summarize here a lot of what we said. Use formal business. You don't want to spend your developmental days of a new business fighting in court generally. I suppose some people like to fight in court, and some people might view part of the monetization of their business is getting money out of court, like people that hold a lot of patents. But generally, you want to develop your business, you want to develop your ideas, stay out of court, use formal contracts, be careful with your, in particular with employees and independent contractors, NDAs in place with any potential partner that's you're going to be sharing confidential information with. Be very clear on intellectual property and the ownership thereof, and the licensing and assignment thereof. Keep good records showing your performance of how you're performing your contract. If the other party's not, keep records of that as well, and make sure that you have records of employee performance, particularly if it's not satisfactory or not superior. You want to have a record that employee has his or her faults, so that if down the line you're going to end up terminating that employee, you can terminate them potentially for cause, but certainly protect yourself from a discrimination claim, or try to protect yourself from a discrimination claim. Next slide. I guess that's it for the formal slides, and I think we have probably gone past the time, but I'm happy, I'm happy to take further questions, Tobias, if we should stay on, or Vivian.
Yeah, well, thank you very much. A really very informative afternoon, and I guess many of the questions were answered. So for now, because we're running out of time, we can probably entertain 2 or 3 questions.
I have a question, but I know that we don't have a lot of time. So if other people want to go first, because I already asked a lot of questions, yeah, please do so. But yeah, otherwise I have a question.
Yeah, I have a question that could probably be answered quickly. As I mentioned in the chat, which comes first, sales patent, and the patent, which one is it? IP design or IP utility, and then after that, is it international or domestic? Which ones come first?
Well, it really depends. I mean, it's typically for a U.S. business. Taking the last question first, you would, unless you're planning on doing all your, I mean, what your patent does is it protects your company from someone else, using your technology, your invention to make money somewhere. And so if you're likely, and you may not care a whole lot, if you're not going to do anything ever in Europe or Asia, you might be fine if they use your invention in Europe or Asia. You probably won't be thrilled. You probably like to get some money from that, but it may not be the end of the world for you. But you don't want them using your invention to compete with you. And so what I would say, if you're a U.S. company and you're expecting most of your sales ultimately and revenues to come in the U.S., you probably first file in the U.S. And then there's ways to leverage off of the U.S. filings with, in the European offices. And so that's, most companies that work with in the U.S. start with their filings in the U.S. and then decide whether they want to file in Europe. And if they do, how they're going to, basically use the U.S. filing and the U.S. filing information to leverage off of that. But that's the, in terms of design versus, I'm trying to remember the first question. I mean, the difference between a design and a process patent is not what comes first. It's really what your product is. And so so you typically, you have a lot of products and which means you would have a lot of different filings that would cover, in some cases, process, but generally, design patents are easier, if you will, to prosecute. When I say prosecute, I mean get granted than process patents. And so, and I'm a corporate lawyer, so I'm not a specialist in these areas, but I do know that generally it's, process patents, can be a little bit harder to explain because the question is what's unique about your process. But I think, so if you only have money for one patent and you can get a design patent, I would do the design patent. I hope I answered the question. I'm not sure if I did, but hopefully I did.
Okay, and the other one was, is patent more important than sales, or do sales first and then patent?
Well, when you say, so you mean getting yourself to where you're going to have sales? I mean, I think what you want to do, if you're investing in, if you've got limited dollars to invest, I'm never going to tell you that you should invest, the limited dollars in a legal process like a patent versus trying to earn revenues. But if you can patent, if you can patent at the front end, you're going to want to patent before you have significant sales, so that people can, it makes it less likely that people can, take what you've sold, buy it, observe it, reverse engineer it, and compete with you. Now there's some businesses where the most important thing is being first to market. And so, and so people don't worry so much about, trying to figure out how to get it patented. But if you truly have a unique, medical device, or you're developing a drug, or you've got, some machinery that's going to, change the world, you start selling it without intellectual property protection, and it's going to be, hard for you to protect that if someone comes in with bigger resources than you, and decides they want to reverse engineer what you've done and take off from there.
Thank you.
Yeah, thank you, Anita and Mark. Mark, just one quick question. I just want to backtrack a little bit because many of our students are actually presenting or pursuing a social enterprise setup. Can you say something a little bit about certified B corporation?
Yeah, so there's various types of entities, including the certified B corporation, where you can, the general goal of for-profit enterprises like a corporation is to maximize value for the shareholders. In the context of social benefit corporations, certified B corporations, and other similar entities, that primary goal is tempered by the ability under statute to look at all kinds of other different factors, like benefit to the community, benefit to the neighborhood, benefit to society, benefit to the environment. And what it does is it protects it protects the board members and their officers as they make decisions for the corporation to take certain actions. It protects them from a shareholder saying you didn't do what you had to do to maximize shareholder value. You took actions that were contrary to to maximizing profits for shareholders, which in a general C corporation historically could be problematic. But the social benefit corporations allow you to take into account other factors and insulate board members for taking into account those other factors that might reduce profits that shareholders could otherwise earn through the entity.
Thank you. Thank you so much. All right, we're running out of time, and I know, oh, Pui-san, I see that you want to say something. Okay.
I just wanted to ask a question. Like, so in your opinion, at what point should you, when you start a business, at what point should we start engaging an attorney? Because like, is it at maybe that one time when I'm working on a contract, or, but I meant more for at what point in your starting the business, when should you go talk to the attorney? Like maybe when you when you're ready to incorporate, or even earlier, and you know, and finding one that you want to work with throughout the whole process.
Yeah, and I think it makes sense to talk to someone, again, who's still self-interested, but early on. It doesn't mean that, you know, it may be on a pro bono basis, or it may be, you know, through someone like an LLC, or it may be you're paying them. But even if you're paying the attorney, those initial conversations, you know, oftentimes attorneys will give you some advice, free advice at the front end, but those initial conversations don't need to be long and involved and expensive. It's, you know, here are my thoughts. Here's what I'm thinking of doing. What do you think? Should I form a corporation? Should I form an LLC? Should I, you know, should I think about intellectual property protection? And you know, you can get some general advice, either free or fairly inexpensively at the front end. And I would, you know, have at least that kind of a conversation early on, even before you form the entity. And then, yeah, as you enter, you know, looking at entering contracts with third parties, it is generally a good idea to have an attorney, you know, run their eyes over it, unless it's, you know, entirely immaterial, or unless you're, you know, very sophisticated business person, or, and a lot of you probably in this class have a good level of sophistication, having, you know, being interested in being an entrepreneur and taking the class. But I generally, you know, without trying to sound too self-interested, do encourage at least, you know, high-level use of an attorney early and often to make sure you're avoiding problems for your business, you know, down the road, whether being trapped in an unfavorable tax situation, or you know, signing a contract that gives away more rights than you might have intended to. And again, I think, you know, working with a group like LLC, you know, some of this for companies that are just starting out that can't afford, you know, outrageous rates of corporate attorneys, you know, seeking to do some of this pro bono makes good sense.
Thank you. Thank you so much, Mark. Tobias?
Yes, I just wanted to mention that I pasted the application link to our online application for one-on-one advising with a volunteer attorney into the chat. And yeah, that's the best way to get in touch with us if you haven't already. And then once you submit the application, one of our team members will get back to you and conduct an intake call with you and discuss with you further how we can help you.
And the other thing, Tobias, I would just mention, it was part of the question that was just asked that I didn't respond to, which is, you may start off with, you know, pro bono consultations or pro bono representation. And then does that mean that you're going to be working with the same lawyer when you know, do a $2 billion public offering? No. I mean, you know, companies often graduate from, you know, pro bono, and maybe they, you know, if they, you know, get, you know, going to be bigger ultimately and look to do big exit transactions to, you know, to firms and lawyers that specialize with startup companies. And then, you know, down the line, when you bring in venture capitalists, the venture capitalists may say, hey, you really should look at hiring X, Y, or Z. And then, you know, maybe another lawyer for the public offering. So, you know, you're not, it's nice to have one lawyer and continuity through much of your life, but you're not certainly, you know, bound to that at all.
Agreed.
Mm-hmm. Okay, well, thank you very much. I could not really extend more how much we really appreciate you supporting our center and sharing your knowledge, your expertise with us and our students here. So with that, I guess we can close the session, and I look forward to continuously collaborating with LSE and probably having Mark again in the future.
Thank you very much. I enjoyed it.
Thank you very much for having us.
Thank you.
Really enjoyed it as well.
Good luck, everyone.
Thank you.